Welcome back to Amber Community's podcast series. I'm Sarah Richardson and I'm a Senior Associate at Arnold Dallas McPherson Lawyers. And today I'm with my colleague, Sean.
Hi, Sarah. My name's Sean Marcus. I'm a partner at Arnold Dallas McPherson Lawyers.
Sean, in the last couple of episodes, we've discussed what we often describe as the no-fault entitlements. And there's three of those: lost income, medical-like expenses, and impairment benefit claims. And today we'll turn the conversation to what we describe as common law claims. So for any individual who has been in a road incident that has been caused by the negligence of another driver, they may well have an entitlement to common law damages. The law is quite complex for common law claims, but can you try and break it down?
As best I can, Sarah. So someone who suffered from permanent injury through the negligence of another individual may have an entitlement to damages for pain and suffering and loss of income. And that's a really important entitlement because for a number of reasons, but one being the Transport Accident Commission benefits for no-fault entitlements have a limit of only 3 years for wages, and any compensation otherwise normally needs to be obtained through the pursuit of a common law damages action for future loss of income. But in addition, as a recognition of of what someone has had to go through and the treatment and the trauma, that a payment for pain and suffering damages can have a really important role in someone's future and some role in restoring what's gone wrong in the past. And so we see it as a very important role and an entitlement for individuals to pursue. Yes, and it can often, it's a complex claim and it does take some time to get going. We often start with an application process through the TAC, and us at Arnold Dallas McPherson use the protocols. I think it's important for clients to work with lawyers who use the protocols. I'm very familiar with them. Do you agree with that? Yes, that's right. The protocols which are set up allow for individuals to bring common law damages actions and give themselves the best chance of resolving their matter with the TAC without the need to litigate the matter through a court. And the protocols are set up to best navigate a resolution prior to needing to think about a court proceeding, which can add extra stress to the matter. I think we must point out that there is a time limit on common law claims, so they must be brought within 6 years of an incident occurring. I think probably another aspect to touch on is that these applications do take preparation and they can take time. But with the protocol process, there are plenty of opportunities to sit down with the TAC and to try and resolve these claims without having to go through a court process. That's right. The first matter we must prove is that the individual is suffering from a serious injury. Our client has injuries of a significant enough level that they qualify for the definition of serious injury as defined by the legislation that we deal with. There's two ways to do that. The first way is what we call the fast track method, and that is a very simple process where we ask the TAC to consider the relevant medical evidence and see if they agree that the injuries qualify for what's known as a serious injury. If that is the case, then we enter a settlement negotiation period with the TAC. The second way is a more thorough process where we must set out an individual's circumstances via affidavit material and relevant medical records and reports and seek the TAC determination as to whether or not they do believe the injuries qualify for the definition of serious injury. So I guess in sort of summarising what we've spoken about, it's pretty important in these kinds of claims that legal advice is sought and early in order for us to try and get the claim moving and organised, and so that they can get a result or a resolution with the TAC sooner rather than later. Correct. And that allows someone to move on following the resolution. But importantly, that 3-year window of payments, we really like to see that someone is able to resolve their matters with the TAC prior to that. Then 3 years of lost earning capacity payments finalising. so there's no further financial hardship.
Yeah, absolutely. I guess just in closing, whilst we've just sort of emphasised that we do try and get things moving as soon as possible, we always work at the client's pace.
Correct.
Well, thank you very much. It's been a pleasure speaking with you, Sean.
Thanks, Sarah.